We hold these truths to be self-evident. Corporations are not people. Money is not speech. This is not a Christian nation. And the government of the people, by the people, for the people, shall not perish from this earth. Welcome to Disorderly Conduct.
Hey guys, we're back for another episode of the Disorderly Conduct podcast, here with my usual cohort, Jesse, Fingers, Mayhem, and today we have a very special guest. I'm very excited to introduce Eric Segall, Ash Family Chair Professor at Georgia State University College of Law, which was my alma mater, and I've just always admired your particular views on the Constitution, so I'll give you a second to introduce yourself.
Well, thanks for having me. I've been teaching constitutional law at Georgia State since 1991, which is the same year Justice Clarence Thomas came on the bench. That is too long for any Supreme Court justice and probably any law professor to be around. But I think I love teaching and I love doing work on the Supreme Court. And as we'll talk about, I think I have a reputation for being a hypercritic of the Supreme Court, but that's not a partisan critique. I have been hypercritical of the Supreme Court in liberal times, conservative times, moderate times. I just think it's always been a faulty institution in American politics or any politics. So that's kind of where I stand.
Guys?
I have questions bubbling already, but I assume you're going to get into the meat and potatoes of it that I don't want to tip my hand, but I'm very interested to get into the conversation.
Did you guys want an intro?
Well, yeah, I'm Fingers. I'm a 30-year working musician, accountant by day, amateur historian, history buff, and enthusiastic amateur economist. And I'm here to talk about, issues that are facing the nation, wealth inequality, and our slide into tyranny. So I'm interested to get deeper into our conversation today.
Yeah, I guess I'll go next. How's it going, guys? I am Jesse. I am IT guy by day and concerned citizen all times of the day. I also would consider myself a very amateur historian. I love to read. I love to read history. I'm a nerd. I have favorite historians, which is great. But yeah, I'm just here to fight back against this fascist takeover.
Hey, I'm Mayhem. I'm a 22-year special ops veteran, specifically in unconventional warfare, resistance, and information operations. So I spent quite a bit of time overseas working in that arena. Post-retirement, I also work in IT, cybersecurity, and cloud architecture. So I'm also Bobi's co-founder in the Money Out of Politics movement. And yeah, very concerned citizen. I've seen this before, both in history and in recent times overseas in different countries. And it's beyond a point of concern at this point. So,
Thank you for your service.
Thank you.
All right, Professor Segall. Now, you are a nationally recognized scholar of constitutional law, so we appreciate you being here today and taking some time out with us. And I know you are an accomplished author as well. So you're the author of Supreme Myths, While the Supreme Court is not a court and its justices are not judges, and also originalism is fake. And I know you used to have a podcast, as we've discussed. Hopefully we'll get to work together on that in the future. And I know you appeared on CNN, MSNBC, a lot of accolades. But for people, well, actually, let me start with this. So you've been teaching constitutional law for over 3 decades. What first got you interested in tearing down the myths?
I always wanted to teach. And the truth is, I went to Emory University, and in 1979, I was majoring in English and history and thought maybe I would go be a professor of one of those things. I'm a very on-the-ground guy, so the advice I got was don't even think about it. There are no jobs. Forget about it. If you were summa cum laude from Harvard, you still wouldn't have a job in 7 years. There are no jobs. And I said, okay, maybe I'll go to law school and try to teach that. And I was told, well, that's also incredibly difficult, but that's easier. So, and I always thought maybe I would be a lawyer. So I went to law school, but I always had it in my mind that I would eventually teach. So I ended up going to Vanderbilt Law School and then clerking for 2 federal judges in Atlanta, one on the district court level, one on the 11th Circuit. But it was my district court experience, and I had a unique one. that was full of constitutional law cases. And most federal lower court judges don't do that. 98% of their cases are either diversity cases under state law or statutory cases involving federal statutory law. But this is before any of you were born. This is 1983 to 1985. Atlanta was home during those days to what were called the Mariel Cubans, who had come here escaping Castro, and it raised all kinds of constitutional law issues. And my judge had that case. We also had a couple other big con law cases, and that got me interested. So then I went to work for a big law firm for a while, hated that every second, and then went to the Department of Justice under the first George Bush. And at the Department of Justice, they can't reward you with money or anything like that if you're a trial lawyer there. So what they reward you with is good cases if you do well. And I guess somebody thought I wasn't bad. So within 2 weeks, I had more experience than I had at a year and a half at my big law firm. And I ended up working on Iran-Contra. I ended up working on a huge freedom of religion case out of California. I ended up working on Lockerbie. I ended up working on the Congress telling the president to close, at the time, the PLO observer mission to the United Nations. That was very controversial. And all of these cases were front page cases, and they're all con law cases. And after about 3 or 4 years of that, where I got really good experience and handled most of those cases myself, not the Iran-Contra case, but a bunch of other cases. And by the way, I will say this. I'm allowed to say this. I learned stuff during the Iran-Contra case that I can't reveal to this day that formed some of my opinions about the relationship between government and individuals. I actually represented the National Archives in a this is timely to today's world, or the world of 2 years ago, where George Bush was president, but the independent counsel wanted Ronald Reagan's records. And we litigated that, whether, they were all under the Presidential Recording Act and Records Act, and they were all not processed yet. The same thing happened during the Trump administration. So my experience at the Department of Justice was really fun in the sense that it was interesting. And now this is crazy, but I want to be honest about it. Coming from Emory University and Vanderbilt Law School, Emory's a top 20 university. Vanderbilt is ranked 17 in the country, always 16 law schools. I had virtually no chance of getting a teaching job. The legal academy is incredibly elite. A few years ago, I actually wrote an article about how elite it is for the Journal of Legal Education. It's more elite than you can possibly imagine. But I got lucky. Georgia State was only about 8 years old, and I was happy to live in Atlanta if I could get a job. And they were interested in me because of my Atlanta connections a lot. And then, but I didn't know about Georgia State in 1990. No one did, really. And I called my judges, and they were both, it's going to be a great law school. You should not, Atlanta needs a public law school. And they were right. I know Bobi's an alum, but I think Georgia State took off very fast. And we have great students and great faculty, because Chicago, Philadelphia, all these big cities have like 8 law schools. Atlanta has Emory and Georgia State, and then John Marshall. And then Mercer is, 60 miles away, and UGA is the same. So I've loved teaching, and I've loved writing about the relationship between the government and individuals and groups, mostly through the lens of the most powerful court in world history, and maybe the worst political institution in any free country in world history.
Well, I learned something today. COINTELPRO must have been quite an interesting case. So would you say those cases sort of, I guess you said those cases sort of shaped your view on SCOTUS?
The case that shaped my view on the Supreme Court was a freedom of religion case in San Francisco that raised the issue, what can the government give to private religious schools? And the law has changed. Well, law on everything has changed since 1990, everything. Abortion, affirmative action, guns, everything has changed, which tells you something about why the court is not a court. But in any event, we had to lose that case. In fact, I went to my political bosses and said, under existing law, we don't have an argument. I can't find a non-Rule 11, meaning a non-frivolous argument. Now, it turned out that case involved the Department of Education, the state of California, the city of San Francisco, the Archdiocese of San Francisco, and the San Francisco Unified School District. The United States Catholic Conference came into the case too, and they had this brilliant lawyer who clerked for Justice Warren. Now, the Catholic Conference's interest in this was getting as much money to religious schools as they could. I at first said I wouldn't work on the case, but when I went to because I'm for separation of church and state, but when I went to San Francisco and saw the schools, I grew up in Long Island where private schools were all for rich people and all that stuff. What these were very poor Catholic schools, trying to take kids of color off the streets and give them a decent education. I still wouldn't vote to give money to those schools. But as a constitutional matter, I was okay saying if the voters want to do that, that's okay. But we really had to lose the case. And my co-counsel, who was brilliant, came up with a argument that was non-frivolous by this much. Just barely. I could sign my name to it, but just barely.
Just barely.
And we ended up winning that case. And that gave me kind of a legal realist perspective. And by that, I mean where judges have discretion. And in this case, the judge had very little, like a tiny amount. But even when judges have a tiny amount of discretion, their personal values, ideologies, and politics is just a subset of values and ideology. Today's Supreme Court's main value is help the Republican Party. That was not the Supreme Court's main value, for example, in 2010. It was important to them, but they had other things because Justice Kennedy, that wasn't his only value. But this Supreme Court's only value really is help the Republican Party mostly. But anyway, when judges have discretion, their life experiences will determine what they do. And that became clear to me as a lawyer litigating constitutional law cases. But in reality, as Bobi would tell you, I think, and every lawyer learns in law school, that no matter what case you have, whether it's contracts, torts, property, or constitutional law, the first thing you do is research the judge. And there's a reason for that. We don't have computers spitting out legal decisions. We have human beings. Everything I'm saying to you is a product of my environment, my values, my general ideas about life. And that's true for judges. Now, having said that, I know a lot of lower federal court judges, a lot of them. And recent Trump judges notwithstanding, and recent liberal judges in the Ninth Circuit, California, notwithstanding. Most lower federal court judges try to follow precedent, prior cases. They do, in good faith. And for one reason, selfishly, they don't want to be reversed. But second, right. but even leaving that instinct aside, they want to do their jobs. And they're taught in law schools, they're taught when they become lawyers that precedent, prior cases matter. Now, there are some judges, famous judges now, Judge Ho in Texas and a few others who don't care about precedent, but most do. That makes them judges because they can't do anything they want to do. The Supreme Court is not bound by precedent at all. So they don't have that constraint. And that's one of the main reasons they're not a court. I'll finish with this and this get to the next question. I know I'm droning on here. I was very fortunate in my life to have as a very close friend the most important and famous judge in America, maybe American history, not on the Supreme Court. That's Judge Richard Posner of the Seventh Circuit, who was named America's leading intellectual of the 20th century. Not just legal intellectual, most important intellectual. The smartest man I've ever met. Some people hate him, some people love him. He's very controversial, but no one denies he is probably the smartest American judge of the last 50 years, Supreme Court or not. And we became very close friends, he has Alzheimer's now and it's terrible, but we became very close friends. And he really influenced me. So I'll give you an example of how lower courts are different than the Supreme Court. Judge Posner was one of the few judges in America who, after the Heller decision came out in 2008, for the first time in history, giving Americans the right to own guns separate from malicious service, a truly horrific decision on every level, written by a racist, sexist, homophobic Justice Scalia. I can back that up in a few minutes if you want. But in any event, when that decision came out, two lower court judges, both Republicans. The other one was Judge Wilkinson in North Carolina, who also is a famous judge, not like Judge Posner, but famous. They both destroyed the decision, just criticized it from beginning to end. From Judge Wilkinson's perspective, the Heller decision and Roe versus Wade were indistinguishable. I agree with that, by the way. I am radically pro-choice. I would vote for a constitutional amendment giving women the right to choose. I wish we could have that. Roe versus Wade was a terrible decision. And that's what he said. Judge Posner criticized Heller on more prudential, practical grounds because he was a pragmatic judge. Despite publicly writing and criticizing this decision, 2 years later, he voted to strike down Illinois' gun law. And this is the most independent lower court judge in the last 50 years. He did that, and I asked him about it, because he understood that his job was to follow orders from the Supreme Court. So that constrained his discretion, even him. And by the way, most lawyers would tell you he was not constrained in any way, shape, or form. But he felt like he had to strike down this Illinois gun law, even though he didn't want to. The Supreme Court never feels that way because the Supreme Court violates a cardinal rule of democracy that no other country has violated that I know of, no free country except Iceland, and Iceland's Supreme Court doesn't do very much. Never, ever, ever, ever give government officials largely unreviewable power for life. Who does that? Once you have largely unreviewable power for life, we have left democracy and we've headed someplace else.
Mayhem and I had a conversation about discretion with judges and its effects on the justice system the other day. I know I had questions for you, but I feel like this conversation is going to go straight to democracy and where we're at right now anyway. So
Is what
I would like to give them a chance to ask you questions that they may have. I'm sure there's.
Yeah. I mean, first of all, I'm older than you think. You were saying there was all this stuff happened before we were born. I graduated high school in 1985. So all the cases you're talking about are all the greatest hits of, I know about all. There's a lot of personal touchstones. My mother, who's a nurse, worked the Mariel boat lift. She went down there and volunteered to work with the incoming refugees. Yeah. And make sure that they had medical care. Because these people are 90 miles at sea in boats that weren't really meant to, traverse the open ocean. And then you mentioned San Francisco, Catholic schools in poor neighborhoods. You didn't mention names, but I suspect that the wife or the school that my first wife went to, who's the mother of my son, is probably one of those schools because she went to school in the Mission District. So,
that's where I was.
There you go. Yeah. I mean, and I lived in the Bay Area for 30 years. I'm not there anymore, but the thing that you said in your intro and you reiterated here was you said it's flaws as an institution. And I'm curious if you feel like that flaw is baked into the Constitution. And then, of course, Marbury v. Madison kind of invented powers for the SCOTUS that wasn't necessarily written in the Constitution, right? So that's my curiosity is
okay. So the phrase that gives judges life tenure is good behavior. In Article 3 of the Constitution, judges of the Supreme and inferior courts who have served during good behavior and their salary can't be reduced while in office. Now, good behavior is ambiguous, right? It could mean a lot of things, but history does tell, and history is usually completely, worthless as far as I'm concerned in figuring out hard questions, but not this one. They meant life tenure. There's just no question about it. And I think we all agree. I've never met a person who doesn't agree, a smart person, that judges need to be independent. So what European countries do, what Canada does, what Australia does, is either have a retirement age or a fixed term or both. That's what 49 out of 50 states do. Rhode Island is a little weird, but we all agree we don't want judges to think about getting fired when they issue their decision. So independent, and of course the founding fathers thought judges would be appointed at 50 and die at 60. Or at least, that kind of thing. But you said something about Marbury that isn't true. So there's a myth that Marbury was a overreach when it comes to judicial review. The idea that judges would strike down laws, that Marbury gave the federal judiciary a power that the founding fathers maybe didn't think they should have, et cetera, et cetera. None of that is true. To really understand how we got here, you have to understand a debate, and if this gets too wonky, tell me, between Alexander Hamilton, the person, not the actor, or the character, and a guy named Brutus as a pen name for somebody. When the Constitution came out of Philadelphia in 1787, there was a big debate between those who wanted it and those who didn't, and Brutus did not want the Constitution, and for many reasons. One of his big reasons, though, was this idea of giving judges the power to strike down laws and serving for life. He said if you put people in that position, they will eventually be free of all constraints, and this is next sentence is direct quote, free of heaven itself. And he warned everybody, this is a terrible idea. He was right. Alexander Hamilton responded to that directly in the Federalist Paper number 78. That's the famous line where Hamilton says the Supreme Court is the least dangerous branch of government because they have neither purse. What he exactly said was they're not a threat because they have neither purse nor sword. The Supreme Court has no money, only the money Congress gives it, and it has no sword, it has no military. But then he went on to say, in addition to those factors, judges will not strike down laws unless they are, quote, at an irreconcilable conflict between the Constitution and whatever the political official is doing, which is, by the way, the world I want to live in, a world where judges only strike down laws. You know, the president has to be 35. Sorry, we can't have a 33 president. As terrible as it is, as anti-democratic as it is, as much damage as it has done to America, the Constitution is clear. The Senate has to, every state gets 2 senators, even if California has 50 times the population of Wyoming. That's an insane thing for any democracy. But, you know, we know what 2 means, and we know what every state means. Marbury versus Madison involved a law that didn't exist. He made up a law to strike it down because Thomas Jefferson wanted to make somebody a judge. Jefferson said publicly pretty much he wouldn't do it no matter what John Marshall said. They hated each other for both personal and professional reasons. Jefferson was never going to abide by a Supreme Court decision, in that case, Marbury versus Madison. So what Marshall did is he made up a federal jurisdictional law that didn't exist and said it gives us jurisdiction in this case, but we can't constitutionally exercise it. What do I do when a federal statute gives me jurisdiction, but the Constitution says I can't have jurisdiction? Well, I have to go with the Constitution and not give Congress's law effect. Well, Congress didn't care because that he misread it. The law he pretended to exist didn't exist. He did say, I have the power to tell the president what to do when the president violates the Constitution, but I can't do that in this case because I don't have jurisdiction. So what Jefferson did is he went to the media at the time and complained and yelled and screamed and said that infidel fool John Marshall, that idiot, that he says he can tell the president what to do. He can't. The media said, shut up, you won. The case was dismissed. We don't care. I believe on his deathbed, I'm not sure about this, but there is hearsay, rumor, evidence. On his deathbed, Jefferson complained about Marbury versus Madison. Nobody cared. So if we had judicial review as John Marshall explained it and as Alexander Hamilton explained it, the law that he made up would have been completely inconsistent with the court's jurisdiction. So in that case, there was a complete inconsistency. If we had that kind of judicial review, I'd be in favor of that. And the next time the Supreme Court struck down a federal law after 1803 was 1857. It did strike down a bunch of state laws, but it took them a long time to get back to striking down a federal law. And of course, that was the infamous Dred Scott case where Congress tried to end slavery in the territories. And the Constitution says Congress has complete authority over the territories. And the court struck that down in Dred Scott and said black people couldn't be citizens. And it's from 1857 on that we get an institution that strikes down laws when they don't like the laws. And that's why in most major Supreme Court cases, they said it in Roe, they said it in the Nixon tapes case, they said it in a famous case where a Democratic Supreme Court full of 9 Democrats told President Truman he couldn't seize the steel mills in 1953. In all those cases, the court always says, in Griswold versus Connecticut, the contraception case that led to Roe, in all of those cases, there's a sentence or two where the court says it's not our job to say whether we like laws or don't like laws. Our job is to compare a law to the Constitution and only strike it down, if it's inconsistent with it. But that's not our system. They strike down laws they don't like. That's Democrats, moderates, liberals, conservatives, Republicans, all of them. And they've done that since 1857. And more often than not, it's done anti-progressively because these are elite lawyers whose job is to maintain the status quo. When they do things progressively, like Roe, like the same-sex marriage case, which, of course, I think almost no laws are unconstitutional. But bans on same-sex marriage are unconstitutional because I can read, no state shall deny any person the equal protection of the laws. When Jim and June get married, they get financial benefits from the state and others. When Jim and John get married, they don't. That's a denial of equal protection of the laws. It's a textual thing. Brown was correctly decided, obviously, for similar reasons, though not enforced by the court ever. It was the Congress that enforced Brown eventually. But if we had limited, modest judicial review, then I get that. We have a written constitution, and we should follow it when it's clear. But the idea of judges just making up doctrines across the board to limit what elected representatives can do. And if anyone out there is listening to this thinking, well, but we need the court as a pushback against, for example, Trump or other strong presidents who do terrible things, or strong Congresses, or even strong states, it turns out that when things really matter, the court backs down, and always has. The court has never saved us. The court will never save us. The only reason the Watergate tapes case came out the way it did, the only reason, was because they knew Congress had their back and Nixon would have been impeached. It's the only reason. There's no other reason for that. And also Nixon was an incredibly unpopular figure among elites. But the real reason is they knew Congress would support the court. One last thing about this. In 1875, Congress had passed a law prohibiting discrimination in hotels, restaurants, and places of public accommodation. Now, leaving aside the issue whether that law could have been enforced in the South, probably not. But leaving that aside, the court struck that law down. And then we had, 2 generations of Jim Crow and segregation. That people don't talk about that case, so when I say that case destroyed America for generations when it comes to race, people say, but look at Brown. Brown wasn't enforced either for 10 years. So even if that decision at all, in 1963 America, 9 years after Brown, the South was 98.6% segregated in public schools. It was only the Civil Rights Act of 1964 that changed the South segregation. If the civil rights cases of 1875 come out differently, symbolically, it would have been very important. And it would have changed a lot of things. And of course, 20 years after that, the court explicitly affirms separate but equal in the famous Plessy case. So when I talk about the court to progressives and liberals and they get mad at me for this kind of thing, I say to them, the one thing you guys always say is the court is good for minorities, right? It's a counter-majoritarian institution. No, that is categorically false. And I don't, by the way, you can make your own balance on this. Donald Trump does not get elected president without the same-sex marriage decision. I'm not, it's a rational thing to say it's better that we have same-sex marriage than not have Trump. I'm not impugning anyone who says that. But make no mistake, it was Roe and it was Obergefell that led to Donald Trump in 2016.
Is that like a pendulum thing? You know what I mean? Like,
No,
why do you think push the link?
The history of that is interesting. And so Roe is 1972.
Right.
And in 1977, Jerry Falwell, sorry about that. That wasn't me, was it? No. Jerry Falwell, who was by far the most important evangelical of his day, he and Pat Robertson, but Falwell was more important. Jerry Falwell, and of course, Jerry Falwell Jr. was critical in 2016 to Trump getting the evangelical endorsement. He wasn't going to get it because he's a real estate mogul from New York. They hated him. And he may have been pro-choice. They didn't know. So in 2016. So Jerry Falwell was asked in 1977, what about abortion? What about Roe? And his answer was, not my problem. I don't know. It's a hard issue. We don't have a strong, this is America's leading evangelical.
Moral majority.
We don't have a strong opinion on that. Ed Meese, who was Ronald Reagan's personal friend, instrumental in his 1980 campaign, eventually the Attorney General of the United States, Ed Meese reached out to Jerry Falwell and other leading evangelicals and said, come in the fold to the Republican Party. Come support us. Come support us on Roe and crime, basically, or Miranda, but mostly Roe. And we will give you access to power. And that changed America forever. That one decision. And then the tail end of that is Ronald Reagan did make the good campaign promise to appoint a woman to the Supreme Court. By the way, you never hear Trump or the anti-DEI people talking about Reagan's promise to appoint a woman no matter what as his first Supreme Court justice. He did that, in 1981 America, there were no, think about it, to be a qualified person for the Supreme Court in 1981 America, you had to go to law school 20 years earlier. There were virtually no women in power, So Sandra Day O'Connor was the only even remotely conservative woman who could be eligible for this. And that made the evangelicals crazy. And he had to go, because by that time now, Jerry Falwell used abortion incredibly successfully. And now his flock was anti-abortion. So they literally invited Falwell to the White House. And Ed Meese said, listen, we had to do this, campaign promise. The next two, at least, if not the rest, will all be staunch anti-Roe people. And the next two people nominated were Scalia, who got it, and Bork, who didn't. But of course, Bork was anti-Roe to the bone. So the role of evangelicals here are incredibly important. Now go to 2016, and Donald Trump is not winning. He's not doing great. And then he gets Jerry Falwell Jr.'s endorsement, and his campaign takes off. And 1 in 5 people actually, it's more than that. It's about 22% of people in 2016 who voted for Donald Trump, according to the polls, said they voted for him because of the Supreme Court. That's a huge number.
I'm sighing because it's just, I usually enjoy Sundays. It's a very sobering conversation.
Yeah.
But I mean, I forgot about that link with Falwell. And really, I think that's where you see the beginning of this Heritage Foundation, right-wing.
Not the beginning of that, but it's where it took off. And make no mistake, Amy Coney Barrett and Sam Alito are both. I'm not saying they both share the same values as evangelicals do, and of course Justice Thomas does as well. Although I don't think he has a religious bone in his body. I think Gorsuch and we have a Supreme Court that was molded by the evangelical political Republican alliance, and that's why we're seeing everything we're seeing.
Right.
So I just want to chip in here. Do you prefer Professor or Eric?
Eric.
Okay. I read one of your papers because I wanted to be familiar with your work. I had read, I think it's to reform the court, we have to recognize it isn't one. And you lay out all the same arguments. And I guess the comment I want to make is, the more I read about American history, the more I'm confused about the bipolar nature of the Supreme Court. And I just want to say that your perspective has got me in like an internal tussle, because it's almost like the missing link. It answers why this doesn't make sense to me, right? Like why Congress can pass, for example, one of my favorite historians is Eric Foner. He's like,
he's awesome. He's amazing.
Yeah, he's incredible. And I read one of his books called How the Civil War and Reconstruction Remade the Constitution, right? The second founding. And seeing how Congress had passed, landmark legislation with the 14th Amendment, and how the Supreme Court, thereafter was extremely regressive. It just didn't make sense to me. It doesn't make sense how a Supreme Court.
Just interrupt for 1 second, and I'm making this point not out of, this is going to be an immodest, not humble point, but I want to make it for a substantive reason. So Eric Foner, I am not comparing myself to Eric Foner. He's one of America's leading, in any way, shape, or form.
But the same name.
But that's the only thing that's. I'm not in his league. But my wife and I took a 3-day kayaking trip once, and was offline for 3 days. It was the best. A few years ago, it was like one of the best things that we ever did. We had our kids, safely tucked away. Anyway, I got out of this kayaking trip, and my cell phone had lit up like a zillion times. Jamil Bowie of the New York Times had written a Sunday column about the books he's reading. And he mentioned both of my books first. And the next book he mentioned was Eric Foner's book. That book you just mentioned. And I thought, well, I can retire today, and I'm a very happy person. But I love him. I think I loved him before he liked me. But his point, though, I think, was that bipolar thing you're talking about there. The court has done some good things. No one is denying that the court hasn't done some good things. And Judge Posner used to yell at me all the time, Eric, on balance, because he's a pragmatist, empiricist, on balance, has the court been good or bad for America? And I would say on balance, it's definitely been bad, but that also depends where you sit, right? Obviously, to some degree. But Eric Foner's book shows with real precision how the promise of the Reconstruction Amendments was undermined by the Supreme Court and the 1876 election, which we don't have to go into, but it wasn't just the Supreme Court. Now, I do want to say everything I'm saying about the Supreme Court does not apply. it applies in description, but not. I want the court to be very strong when it comes to the 4th, 5th, 6th, and 8th Amendment. Nothing I'm saying applies to double jeopardy, self-incrimination, coerced confessions, police behavior, because they're the experts there. Supreme Court judges are the experts there. They run their courtrooms, what confessions get in, what sentences are, all of that should be up to judges. And they shouldn't be deferential. And we need strong judges to protect the rights of criminal defendants because no other judges will. No other political actors will. Leaving aside the question of whether our Supreme Court's been good or bad about that, I want a strong Supreme Court on that. If an Eastern European country called us and said, send us your experts on double jeopardy and self-incrimination, we would send lawyers and judges, right? If they called us about abortion, gun rights, or the relationship between free speech and campaign finance reform, it would be insane to send. We would send lawyers and judges, but that's insane because they don't know anything more about it than, as Scalia once said, 5 people picked at random out of the Kansas City phone book. He didn't act that way, but he did say that once. So anyway, my point is Eric Foner is really right about those Reconstruction amendments, which isn't to say everything the court did was terrible. But on balance, it has been a destructive force. And I don't think that's even reasonably debatable.
Man, the thing that there's so many branches of interest in all of the things that you're saying that I'm interested in exploring. But the thing that strikes me is you'd mentioned how, Marbury Van Madison is 1803, I think you said?
Yes.
And the next one is Dred Scott,
yes.
Right? And the history, it goes right back to the country's original sin. It goes right back to race relations. It goes right back to the 3/5 clause. It goes right back to our entire system of jurisprudence meant to disenfranchise a certain peoples. And what you were saying about the striking down of the Reconstruction amendments, it seems like at every
not striking
step
down, but interpreting them really narrowly.
Sorry, yeah. Sorry, non-lawyer speaking non-precisely. And to your point that it's always been a anti-progressive body, and we see it even now today, right? And just like you talked about, the DEI stuff, which I know hasn't made its way to the Supreme Court, but I'm more talking about cultural forces and, the effect of the institution upon true justice v. injustice, right?
Oh, I'm sorry. I'm sorry to interrupt, but the DEI stuff absolutely made it to the Supreme Court.
Oh,
without the court striking down affirmative action and saying we have to be a colorblind society, which, by the way, we've never been. So for an originalist to say that is insanity. But anyway,
don't get me started.
That affirmative action case emboldened the Trump administration. If that case comes out differently, Trump couldn't be doing what he's doing.
Yeah. Sorry, go ahead.
No, I was just going to say there's a little bit of a distinction between DEI and affirmative action. And
there should be, but not according to the Heritage Society, not according to
right. Yeah, I agree with you.
And not according to Donald Trump. No.
But I didn't know if maybe Fingers was referencing,
Well, that's a political framing. That's a political framing, right? Because it's easier to attack affirmative action, logically, I guess, from as a point of argument than it is to attack DEI. And so conflating the two makes it easier to attack politically. So that's the way I interpret it anyway. But yeah, just when you say originalism, I get a twitch because like these guys that claim to be originalists invent an entire raft of power for the president out of 4 words, energy in the executive, right? Like, oh, those 4 words means he gets to do whatever it's like, you're not an originalist. Like, give me an effing break. Anyway.
There's never been an originalist Supreme Court justice ever in American history.
Yeah. We should get Mayhem into the conversation.
No, I'm just listening intently. I know when there's bigger brains in the room for these types of areas, and I really appreciate the perspective, Mr. Segall. It's very informative.
If Mayhem doesn't want to ask the question, let me say a couple words about originalism, because first of all, it breaks my heart that I have to do this because I wish lay Americans now have this idea, about originalism. That wasn't true 15 years ago, 20 years ago, 30 years ago. The fact that non-lawyers know about this ridiculous idea is insane. If anyone listening to this who's not already a progressive or a liberal comes away with anything, there is no originalist justice. And I can make that point really clearly by just talking about free speech. the Roberts Court is the most activist court in American history, even more than the Warren Court, on free speech issues, striking down this, that, and the other thing all the time. Some of those are good decisions. Many of them are not, but that's not my point. History could not be clearer that the founding fathers were only concerned about prior restraints. What I mean by that is when the printing press came out in England, not far removed from that time period, the government tried to suppress speech before it came out. And that's what they didn't want. But they absolutely believed you could punish speech after it came out. So they passed the Alien and Sedition Act right after the Constitution was ratified that punished political speech. What most Americans don't know is blasphemy prosecutions happened in the late 19th century. 100 years later, we're still putting people in jail for blasphemy. The first Supreme Court decision ever to grant someone relief under the First Amendment's free speech clause was in the early to mid 20th century. There is no originalist case for free speech at all. None. Zero. And they all believe it's very important. And that's just one of 30 other less exciting examples I can give you. Certainly everything involving the, quote, unitary executive is anti-originalist. And by the way, there is colorblindness. We've never been colorblind. And no one who ratified the Constitution, there were some people who wanted to be, and their response was, are you crazy? We've had slavery. How can we start off being colorblind? So
3/5 clause.
We can attack affirmative action and maybe DEI on innumerable policy grounds, but there is no constitutional basis. And yet a court with 4.5 originalists. It's not fair to call Justice Roberts originalist. We can call him a lot of dirty names, and I have. He's an absolute villain in American history, but he's not an originalist. But 4 of them are self-identified originalists, and Alito is a half of one. So we really do have 5 originalists. And my article coming out in the Georgia State Law Review in about 6 or 7 months, which is my last, I'm 67, very long law review article, is called Every True Story Ends in Death. That's a quote from Ernest Hemingway and the movie Brian song. Every true story ends in death, how the Roberts Court killed originalism. Which is so ironically terrible if you think about it. Right. But they're the most anti-originalist court in American history.
I have a question. I'm sorry.
No, go, Bobi.
When you talk about the Alien and Sedition Act and the prior restraint, the consideration of the founding fathers, the prior restraint, how do you feel about it? Because I'm sure you're aware of the Alien Registration Act. And in my mind, listening to this administration, they plan on using, or maybe at some point have planned on using, a portion of the Alien Registration Act that was used to prosecute communists or people who just had communist flyers in their union labor office. And so when they talk about people opposing the deportations, and then they use this rhetoric of an invasion so that they can then categorize us as supporting sedition. I think I enjoy broad free speech. Unfortunately, people use hate speech, but I don't want my speech to then be hate speech when they're in office. You know what I mean? So I support a broad free speech. So I was just wondering how you feel about that. You're more on the original.
I get asked this question a lot, and I admit I don't have a sound. I do a lot of radio. And sometimes I say, I'm sorry, I don't have a soundbite answer. I don't have a soundbite answer to that, but I'll try to be brief. So when I say in 2025 America that a law has to be inconsistent and an irreconcilable conflict with the Constitution, that's my standard. When I say the Constitution, I don't mean the text. I don't mean that, because we can't ignore 200 plus years of history where the text just doesn't matter. So there are practices and traditions that are so clear in this country that take the place of text. Now, I would have much fewer of those than other people. For example, Scalia and Thomas and Gorsuch and all these people try to say colorblindness is a tradition. Obviously, it's not. That's a ridiculous statement. It's not even close to that. But we do have some. So I do think that protecting political speech, defined very broadly to include cultural speech that has a political basis, is a strongly held tradition in this country. And we will be a different country if that changes, a very, very different country. And we can't start over. I mean, judges shouldn't start over. So my answer to you is, when the government is prohibiting speech because it doesn't like the content of that speech, absent incredibly compelling reasons or reasonable time, place, and manner, we can't have 10 parades on the same public street and say, no, reasonable time, place, and manner rules, then I think judges should enforce some strong free speech idea. Now, I could be accused of a little bit of hypocrisy there, because I generally don't want judges doing that. There aren't many examples I could give you like that. But the other one would be something less than an established state religion. Even the conservatives, I think, except Justice Thomas, wouldn't put up with Georgia declaring itself to be a Christian state. I think even Roberts and Kavanaugh would strike that down. By the way, Thomas would not, incredibly, and probably Alito wouldn't either. But there are things short of that are close to established state religion. I think that no one's done yet. Well, I think requiring the Christian Bible to be read in school as a Bible. That's an example. Requiring public schools to teach the Bible as not history, but as religion. I think the Supreme Court would strike that down. And I think that's probably, even this Supreme Court, and I think that's probably a good thing, because of our 200-year tradition of not doing that. So I would require judges either to point to very clear text, which the First Amendment is not, or an incredibly strong tradition that, 90% of Americans who care would say that's a strong tradition we've had. And that's why Roe versus Wade is wrong. It just is. Again, I am radically pro-choice. I met my wife giving a talk to Planned Parenthood. I've worked for Planned Parenthood. But there's nothing in the Constitution, there just is nothing in the text, history, or tradition of our country. 50 years, when Roe was decided, it wasn't correct. Now, whether they should reverse it or not is a different issue after 50 years. I don't take a strong issue on Dobbs, other than horrified by the way it was written, which is beyond the pale by any standard. Citing 17th century men who thought husbands could rape their wives and wives were the property of their husband numerous times in the opinion should be an unforgivable sin. I would probably impeach them for that. Well, it's not a high crime or misdemeanor, but Roe, as originally written, was simply an unauthorized, illegitimate decision. Caused the American left to lose on almost every issue other than abortion that the American left cares about.
What about the argument that it could have been rooted in the Fourth Amendment?
The Fourth Amendment? 14th Amendment.
No, I think there was I've seen some discourse online about it being.
There's no argument it violates the Fourth Amendment. There is an argument that it violates the 14th Amendment in terms of equal protection of the laws. Yeah. But the problem with that argument is I'm not going to name this judge, but I am friends with a judge in Atlanta, a very thoughtful Catholic liberal judge. And we've talked about abortion a lot, and he has very mixed feelings about the whole thing. But he has said one thing to me that I think is true. It just comes down to whether you think the fetus is a human being. It just does. And you can't argue that point. It's not a point that can be argued. Now, I want to be clear about one other thing about Roe. What's not true about Roe, and what I've written about so many times, is that the conservatives painted it as an outlier decision, as a decision that used a method of interpretation. Abortion is not mentioned in the Constitution, so it's not a right. And even Dobbs does that. That's insanity, because almost all of our constitutional rights are like that. And the court does that every day, every term. Colorblindness is like that, just as much as abortion is, or more, actually more. I can make a stronger argument for abortion from the 14th Amendment than any argument about affirmative action. So I want to make that point. But when you let judge make up things like abortion, then you let judges make up things like unitary executive and colorblindness and all the other things that have hurt the American left.
One more quick question on that topic, and I'll let them go. There's a case right now that they're trying to. I think the judge did certify, if I'm not mistaken, the unborn children regarding the birthright citizenship. Do you see that backfiring?
So backfiring is an interesting question. So this one, I lose sleep over this. I have a conflict about this. I have a conflict of interest, and I want to put it on the table. Were the court to deny birthright citizenship to people born here other than some Native American tribes and diplomats. If they were to do that, my 2012 book written during the Obama administration, so during the liberal, why the court's not a court. In 2012, no one believed me. In 2018, a lot of people believed me. Today, the American left buys it hook, line, and sinker pretty much. If they were to do that, even moderates and conservatives would accept my theory of the Supreme Court because it would be so outrageously wrong, so despicably terrible, and so obviously inconsistent with everything America's ever stood for. So now I don't want it to happen. I want the Supreme Court to go with the same birthright citizenship we've always had. I want to put that conflict of interest on the table. I get told every day, you were right. And I say, I don't want to be right. I take no joy in being right about the Supreme Court. None. Zero. You're ahead of your time. I don't want to be ahead of my time. I want to be wrong. I want to be clear about that.
Yeah.
The birthright citizenship should be incredibly easy. The Constitution could not be clearer. Our history could not be clearer. Our traditions could not be clearer. Which makes me think the court will not go out on a limb on that case for fear of the self-preservation.
That has exactly been my argument. I mean, the history of birthright citizenship predates the United States. Wong Kim lays it out beautifully. It's a lengthy opinion. Anybody could read it. And if they pretzel themselves to get rid of that, all legitimacy.
So for the record, let me just say this. I agree with that. I just said we agreed. But just in terms of faulty legal reasoning, if the court did that, I want to tell you where America is right now. If the court did that, that would be still much less persuasive than Shelby County versus Holder. Shelby County versus Holder, it's a crime that case even exists the way it was written. And let's head to the end of, so that case was a watershed for me as well, and for a lot of people, because what happened, so everyone knows that's the case that struck down Section 5 of the Voting Rights Act that required pre-clearance by about 10 or 11 southern states and a bunch of counties when it came to voting and racial discrimination. What non-lawyers don't understand about that case is that Justice Roberts cited a principle called equal state sovereignty, where Congress treats some states differently than other states. It must have a very strong reason for doing so, not just a rational reason. It made Congress have a very important reason. And he said they didn't have one in that case. That principle was invented by him 2 cases, about 5 years earlier, in another voting rights case where the court did not decide the constitutional issues, just some statutory questions. And the way he invented that principle, and I'm not making this up, this has been well documented, is in 1965, South Carolina challenged the Voting Rights Act in a case called Katzenbach versus Moore, and said you can't treat South Carolina differently than New York. You can't treat South Carolina differently than Montana when it comes to racial discrimination in voting. The court said the principle you're or any principle or anything, you just can't treat without a very strong reason. The court rejected it outright, said no. There is no principle that Congress can't treat the states differently once they come into the Union. Before they come into the Union, back in the 19th century, you couldn't give different requirements for Kansas and Nebraska. You couldn't make them come in under different conditions. But once you're in the country, there is no such principle. Explicitly stated, no ambiguity. Roberts took out the part about once you come into the Union with ellipses and cited South Carolina versus Katzenbach for the proposition that you can't treat different states differently without a strong reason, and just took out the part about once they come into the Union. And it's a complete reversal of that case by ellipses, and it's the 180-degree difference of that case. It says exactly the opposite of what it said. Now, had Roberts said, we're reversing that case, that's fair. We can debate, but that's fair. It's not what he did. And the fact that our Supreme Court can get away with that, can reverse a landmark case on the most important statute many people think ever passed in America, the Voting Rights Act, and do so in a way that, it's just a lie. It's a bald-faced lie, those ellipses.
Yeah.
That's one of the reasons Shelby County is so horrible. I can't imagine any argument in the birthright citizenship case being worse than that, because that It's literally a reversal by ellipses by omitting the most important part of the sentence without omitting. And the worst thing is Justice Ginsburg called it out in dissent. So he knew. He knew.
Wow. That's insane.
Sorry for that rant, but it
No,
does.
No, that was I think
That's
it's
helpful.
extremely important, and we see it. We're seeing this, right? We're seeing this manipulation of policy, of history, as you called it, tradition, right? And I think tradition is important. I've always understood precedent to be important, right? When I learned about it as a young kid, I was quick to tell people that's precedent. That's case law now. You know what I mean?
Well, it is important. Every court except the Supreme Court.
Right. And no, but that's a great point, because and I see now, kind of zooming out on a macro level, what you're saying, you get away with that because who reviews the Supreme Court?
And you have life tenure.
So it's funny that we're mentioning this now, because at the end of the paper that I had read from you, I want to read to the group the 3 proposals that you make here. The first one says,
Jesse, before you do that, I would just want to make, I'm sorry, Jesse, one really quick point. It was just a couple years ago where Justice Gorsuch wrote an opinion saying, upholding a coach's prayer at the 50-yard line, saying, hey, he didn't pray with students, so it's okay. And in the dissent are photographs of the coach praying with students. So 3 of them. So America doesn't, okay, fine. So I just want to make that point. In other words, that's just a couple, anybody can go look at it. Go look at the case. There are pictures of the coach praying with students, and the majority opinion says the coach doesn't pray with students. Okay, sorry.
They're just gaslighting America.
yeah,
It happened recently when they're like, the president knows they get due process.
Yeah.
We're literally here because he's not giving them due process. Sorry, Jesse, go ahead.
no, 100%. I agree. So you had laid out 3 proposals of what we can do to kind of check the Supreme Court's power. The first one says, first, we need to end life tenure, like you had just mentioned, which is dangerous enough for any government official, but especially for the people who serve on the Supreme Court, who wield great power and have so much discretion. Second is the nomination process, which Justice Elena Kagan called a vapid and hollow charade
until she was nominated. And then the very first question to her was at her confirmation hearings after something about Chinese food. The next question was, you once called this a vapid charade. Do you still feel that way? And she said no. And I was really upset about it. And I wrote an entire article about that one thing.
I bet. That's insane. And then third, and most importantly, the justification for giving judges the power to strike down laws is that as a country, we need government officials to enforce constitutional commands. So I guess the blaring question in my head that you're attempting to answer here is, how do we check the power that the Supreme Court has? How do we keep them accountable? And perhaps it's ignorance. Do you feel there's more that can be done in addition to what you mentioned here?
That's a great question, Jesse. Last night, I had a career highlight when a professor, an emeritus professor at Harvard Law School, who was my mentor growing up, wrote me with some questions that he was seeking advice on. His name is Mark Tushnet. And he wrote in the 1970s, Jesse, he wrote, the biggest conflict in American politics, this is no longer true of Donald Trump, but before, writing 1970s, the biggest conflict in American politics is we do need judges to keep government officials under the law, but how do we limit judges? That's what he wrote in the 1970s. And it's books have been written about this. Most Ivy League con law professors write ivory tower books about how to do this. On the ground, which where I sit most of the time, I will tell you there really is only one. I mean, ending life tenure, I think, would help a little bit, but there really is only one way. And that is to change the way judges act and the way they're taught to act. They should act like Alexander Hamilton wanted them to act. You have to be humble. He talks about this in Federalist 78. You have to be humble. You have to be modest. You are given a power that is no judge before our country ever had, history of the world. And you have to bring a mentality to the job that if reasonable people can disagree, you uphold the law. In fact, it's more than that. You have to be really sure, like super, super, super sure. And I'll give you an example of a tradition that has worked along those same lines. In America, in the Court of Appeals, Federal Court of Appeals, they're not supposed to reverse the factual findings of lower court judges unless the statutory term is clearly erroneous. They have to find the fact, not just disagree. The facts have to be clearly erroneous. That standard has worked for most of American. There are outliers, of course, but most Court of Appeals judges are very reluctant except the Supreme Court, to overturn factual findings by lower court judges because they're deferential. And part of that is they're not there. The district court judge saw the credibility of the witness. The district court judge saw the lawyers, saw the jury, whatever, that has worked because of the tradition of it, not the words of it. If we could change the mindset of America, if American judges acted the way Scalia wrote they should act in his dissent in the Casey case in 1992, he never acted that way. He struck down over 150 laws. But what he wrote in 1992 was, and he's correct in theory, I just wish he'd, is we shouldn't be in the business of striking down anything absent a great deal of certainty. Now, he didn't act that way. But if we could build that tradition, now how you do that is very complicated because government officials don't give up power, right? And that would be requiring the judges to give up power. So FDR had the right idea. The biggest myth in American constitutional law is Brown worked. Brown didn't work. It was Congress that made Brown work. The second biggest myth is that the court packing plan didn't work. It did. Justice Owen Roberts, a Republican, changed his mind so the New Deal, a Democrat initiative, could go forward. The only way this is ever going to work is through scaring the justices. And there are many ways to do that. First of all, we could have 20 Supreme Court justices. The number isn't in the Constitution. The original court was housed like in an abandoned basement someplace. We could take away the Supreme Court building. They don't get a Supreme Court building. They don't get a big marble palace on a hill. Congress could take away their law clerks. Good luck, guys. Do it all yourselves. The original Supreme Court justices had to travel the country sitting on lower courts. We could make them do that. There are all kinds of ways to scare these people. There's an undersold part of the court packing plan that included changes to retirement benefits. That really scared them. We could we can't reduce their salary, but we can change their retirement benefits. We can't fire them, but we can change their retirement benefits. We can make it lucrative for them to retire. That's a positive way of doing it. So there are all kinds of things we could do to scare them. But unless we scare them, it's unlikely to change.
So I've got a question along this, and Bobi and I, I have a deep interest in law for a variety of reasons. But Bobi and I have had this conversation. I've read over several cases where, you can read the law as it was written and know what the spirit of it was. I'm sure you're familiar with Narlow Wilson's case there in the state of Georgia. That was one where, the law was a mandatory 10-year sentence. And I am personally for, as I think about it as a justice-minded human being, judges having wide discretion, but I'm also for checks and balances. And so when you talk about having judges behave differently and perhaps think differently in their role to protect, let's say, the sanctity of the role, what does that look like, right? And what do we do in terms of the justice system where we can see those clear misapplications of the law or applications of the law that were not intended, where we can maintain that discretion or at least award that discretion while also maintaining that new way of thinking you kind of described?
It's a great question. It's a huge question. When the court struck down Biden's student loan plan, I wrote a blog post that I was very nervous to write. I wrote it very carefully, but I said, maybe it is time to consider that the president, if he disagrees with the Supreme Court, shouldn't obey it. Now, by the way, Alexander Hamilton said that too. He said the justices rely on the executive branch to enforce its orders. And if the executive branch doesn't, then those orders won't be enforced. And that was a check and balance. Donald Trump makes all that conversation now very uncomfortable.
I had a question waiting in the wings about that, so I'll wait.
But over the course of time, Europe does it differently. Post-World War II, Europe looked at our system and said, we like judicial review, because they didn't have it, at all. We like this idea of judges having this authority. No one liked life tenure, and no European countries give judges life tenure because it's the world's stupidest idea. But they did like the idea of judges being stronger, like you're talking about. And there's a great book by Jamal Green, a law professor at Columbia, who's a brilliant man, about this. In Europe, it's more of a conversation. Now, not on paper. On paper, the German Supreme Court has the right to tell the German parliament, you can't do that. But that's not how it actually works. How it actually works is the German Supreme Court on abortion, for example, said a lot of things, and the German parliament didn't like it. And they then engaged in a conversation, a literal conversation back and forth, and a give and take, and a more dialogical relationship than we have. And that's how the European Court of Human Rights kind of works to some degree. And that requires judges to be modest and humble. How we get judges to be modest and humble, especially Supreme Court judges who come out of a marble temple on a hill, won't put themselves on camera except when they're selling books, have life tenure, and have a 180-year tradition of striking down laws. Actually, this gives me the ability to correct something that Fingers said Fingers said a while back. I want to correct the record on this in case some people are listening. It is true the court did not strike down a law of Congress from Marbury to Dred Scott. That's a true statement. But a historian now at Yale, political scientist named Keith Whittington, wrote a book kind of challenging that assumption. What he says is true. It doesn't change. I think it's still a true statement. It is true that from 1803 to 1857, the court acted the way European courts do. The court said Congress passed law X, and now it does apply to this situation. But it so clearly shouldn't apply. And the spirit of it is so clearly opposite to how this law is working in practice, that as applied to this case, we're not going to apply this law. The case stays on the books. I mean, the law stays on the books, doesn't go away. It stays on the books, but it doesn't apply to you, plaintiff, this particular case, or similarly situated people to you. Now, if the Congress really hated that, they could amend the law to be very clear, and then we'd have a constitutional case. But so the court did that a lot. I love that idea. I love the idea of the Supreme Court saying Arkansas passed a law or the Congress passed a law. It really seems unjust in this situation, and it seems not really applicable here, even though the text suggests that it does. So instead of striking it down, which is what the Supreme Court does, we'll just say it doesn't apply to this case. And if we're wrong about this, then the legislature can change it. If we're right about this, then the law stays on the books. And so that's one way of doing that. But I got to tell you, Posner had this theory. I'm always asked, the critiques of my critique always start with they don't see themselves that way. The way you're describing them is not how they see liberals, moderates, and conservatives, all of it, except Justice Souter. He's an exception to this. But leaving aside Souter, they think they're applying text, history, and precedent. Now, the liberals will say there's some values in there too, but they all were brought up in an environment where judges don't bring their values to the table. They rely on text, history, and precedent. And Judge Posner's very well thought out theory of this was cognitive dissonance. Like if you gave Justice Thomas a lie detector test, he would say he's an originalist. He's not, but he would say he is. So we've got to change the cognitive dissonance. And one of Posner's big points, I'm just cribbing him, that's why I'm not taking credit for any of this. One of Posner's biggest points was, and I think this will appeal to you all, the legal profession as a whole, leaving aside what we're talking about, is always looking backwards. What happened yesterday? What happened 10 years ago? What happened 50 years ago? What happened 100 years ago? Judge Posner was a Republican appointed by Ronald Reagan. He was appointed for his antitrust expertise. He had some and law and economics stuff. But he has always opposed that idea. Always. It's like, look forward. How do we want to improve ourselves? Don't look backwards. Look forward, which is actually what they do. They just don't admit it. And they cloak it in the past. But that cloak is so strong that they believe it themselves. And that's a very hard thing to change.
So are you now, so I reading between the lines, I feel like I'm hearing you say that they're looking backward to justify the outcome they want to see going forward. Okay.
And if looking backward does not,
then they just make it up.
And then there's impacts litigation where attorneys, I think Roe is one of these, right, where they're looking for a plaintiff to have standing and create a legal precedent that moves something in a progressive manner.
Both the left, right, both the left and the right of all. The NAACP did that for 100 years.
Yeah.
Plessy versus Ferguson was a test case. Lawrence versus Texas, the case that overruled the awful Bowers case from my state that said two adult men, two adult women don't have the right to go into their private bedroom and have sex. The case that overturned that it happens all the time.
Now, the case that he was originally talking about, the student here in Georgia, and I just want to clarify, I think he's talking about the sentencing guidelines. He was charged as an adult and given like an outrageous sentence. And so we've had this conversation about discretion in that regard. And like there has to be a ceiling, right? Because we've already seen discrimination in the criminal justice system, and so that was sort of just where we had. And I think, I guess maybe if you're going to give wider latitude to the trial court, but not to the appellate courts. I don't know. I'm just trying to think good in my head.
I'm going to give you an answer I give to the media all the time. I try not to opine on things I'm not an expert on. I believe myself to be an expert on constitutional law outside the criminal context, the NBA, and maybe movies. Those are my three things. I'm definitely an expert on the NBA. I could talk about it for the rest of my life. I might retire and do that, actually. I'm seriously thinking about it. But I am not a criminal procedure professor. I am not a criminal law professor. I have familiarity. I can opine as a citizen, but everything I've said so far today is in my expert hat. Take it or leave it. I am not an expert on those matters.
So I have a few more questions, but I want to give the guys a chance before I take the rest of the time.
Same thing. Like my mind is, there's so many different ways. I mean, one thing that occurred to me when you were talking about trying to check their power, because as you point out, once they have power, like self-interest sets in, and, I can't remember the exact name of the guy, but it's like, it's very difficult to convince a man of his position is wrong when his livelihood is, determined by that decision. I'm paraphrasing. That's not the exact word, but it's basically, once you're in a position to hold power, it's easy to justify that power, as you were talking about with Justice Kagan. I almost wonder, like, if you had to have a unanimous decision to strike down a law or something along those lines would be a good idea. I love the idea of packing the court. I love the idea of going to like more than 15. I like the idea of 16-year sentences, because eventually you'd even out, every president's going to get a certain amount of, and it just seems to make things fair. You don't get this like aberrant Trump got to like put a third of the court in place, and they're deliberately taking the strategy of putting young justices in there because of life tenure.
That started before Trump, but yes.
Yeah. Yeah. But I mean, again, non-legal expert looking from the outside and saying, this seemes wrong. This seems wrong. I would love to talk to you forever.
I was hoping for an NBA question, but go ahead.
Is Steph Curry the best of all time or no?
No. Let me respond to a couple of things you just said, though, just because I actually, I have an idea. So let me say this. I am very confident in saying life tenure is an incredibly stupid idea. And I can back that up. I am incredibly confident in my opinion that the Supreme Court has been mostly an anti-progressive institution for American history. I had an idea in 2016 that I am so sure is right, that like 5 people in the country agree with me, but it was at least provocative enough where Judge Posner invited me to Chicago to debate people like him and Judge Easterbrook and other famous judges and Chicago law professors. And then Pepperdine had a symposium and asked me to do it. This is my idea for the Supreme Court. And this is doable. This in a functioning, this could have worked in 2016. And I wrote an entire statute. I never did it before. I wrote not the text. I gave everything. What I wanted in 2016 was Chuck Schumer and I think it was Orrin Hatch maybe, but whoever the two major people on Judiciary Committee, to go to a podium and say the following. From this point, there were 8 Supreme Court justices at the time. Justice Scalia had just died. 4 Republicans, 4 Democrats, 4 liberals, 4 conservatives. Occasionally, a couple of liberal justices voted conservative in criminal cases. Justice Kennedy, famously, of course, was liberal on gay rights and eventually abortion and eventually affirmative action even, although only at the very end. And my idea was freeze the Supreme Court at an even number. That's the first thing. 8, 10, 12, pick your number. The original number was 6. So if you're an originalist, you can't object. The original number was 6. Freeze it at an even number and make it be evenly divided between Republicans and Democrats. What I really meant by that was evenly divided between liberals and conservatives. And I had all kinds of ways to make sure. So if a Republican Republican justice dies during a Democrat president's administration, then the senators, so now that Democrat president has to appoint a Republican. Has to, okay? To avoid him appointing a stealth liberal Republican, a majority of the Republicans on the Senate Judiciary Committee have to agree, or some, I had all kinds of legislative ways to do that. But the basic idea was have an even number of Republicans and Democrats. And if an independent ever came around that everybody thought should be on the Supreme Court, I had a fix for that too, because the independents were mad at me for this proposal. I had a fix for that. That, of course, hasn't happened in like 50 years. But if that happened, I had a fix. And then every Supreme Court case, by definition, had to have at least one Republican agreeing with the Democrats or one Democrat agreeing with the Republicans. The Delaware Corporations Court, which is the number one corporations court in the country, has something similar to this. And I really feel strongly that's how we can do a lot of this fixing. And it turns out Justice Kagan in 2017, while being clear that she wanted a ninth justice, she did say that, but she also said, but 2016 was a fantastic year for us. We talked more, we compromised more, we issued narrower decisions. Now, the biggest pushback I got was, well, then you're leaving things to the Court of Appeals, because an evenly divided Supreme Court means the lower Court of Appeals decision stands. And I said, okay, fine. Then Texas, who have different laws than California, con law, which is different than Florida, New York, and that's fine. If you can't get 5 of 9 Supreme Court justices to agree with you, then it should be a local issue anyway. It should be a local issue anyway. And we have 12 circuit. I'd rather have hundreds of lower court judges wrestling with this than 9 Supreme Court justices, or 8, divided 4-4, or 10 divided 5-5. I think that would go a long way, Mayhem, in getting us to a tradition of modesty, humility, and so did Justice Kagan, by the way.
Yeah,
and had there been a Republican, go ahead, Bobi. Sorry.
Having the opposite party pick the justice, so if a Democrat's in the presidency and they have to pick a conservative justice, I think just by nature of that, you're going to bring in more moderate people who are able to have a conversation and agree. And then my only other, I would add to that, if a justice retires, they should have to wait to the next presidency to get appointed. So you can't strategically
I had that part. I had that issue. But that's an issue today too. Justices dying or retiring in office is a problem today. But what I couldn't get people to see, two interesting stories about this. People always compared that to some ideal world, and I would say compare my proposal not to an ideal world, but to the world we have today. Yeah. And tell me what you think is better. The second thing is there's a horrific human being named Ed Whelan, who used to have enormous sway in the Republican Party. And he helped pick Reagan's judges, and he helped pick the first Bush's judges, Federalist Society, all the way down. Yeah, I don't think he's to his credit, I don't think he's a Trumpster. So to his credit. But Ed was very outspoken, and I called him. We disagreed. We didn't like each other personally. And on Twitter, we had fights, and he really doesn't like me. But I called, and vice versa. But I called him on the phone. I said, Ed, you have been preaching for 30 years judicial restraint. He is not one of the Republicans who wants the Supreme Court involved in all kinds of. You have been preaching how wrong Roe was, et cetera, et cetera, et cetera. Come with me on this. Because if you and I raise our hands publicly and agree on this, that would get attention in legal circles. Because everyone knows you and I from Twitter hate each other and disagree about everything. But I'm doing this for you as much as for me. It'll reduce the power of the judiciary. And his answer to me was, and remember, this is when we don't know who's going to be the next president, but it's likely to be Hillary Clinton. And I said, Ed, you want Hillary appointing the next judges? He said, Eric, I think it's a great idea. And if I could get us from here to there, I would join you. But there is no chance you will ever get from here to there. And he's right. He's not wrong. My proposal fell on mostly deaf ears from all legal people. But when I presented it to knowledgeable New York Times or Wall Street Journal readers, conservative, moderate, liberal, didn't matter. I will tell you the reaction. I don't know how you guys feel, but the reaction was overwhelmingly favorable to this. Yeah. But the legal system is so hard to change.
Well, another benefit that I see to this would be simply the cases that it'll fall on the Court of Appeals. And like you, I feel good, right? Not everything needs to go to the Supreme Court. And that's a great catch-all, right? We're sitting in a circle of 8 people, and we look at it. and we just don't agree, we know we're not going to get the decision, we reject the case and we let the lower court stand. I mean, I think that's a good measure of what courses, what cases should we take. We've got, 8 people here saying this is unconstitutional. Easy take.
My view is that there's almost nothing original. I've only had 2 original thoughts about the court in my life, and that's pretty good because there's nothing original to say. One is the court is not a court. No one ever said that before me, and I'm proud of that. They've said things very similar, but no one ever took that position. And this idea is an original idea. And my standard for original ideas about the Supreme Court is if it's not stupid, we should talk about it. I mean, if it's not obviously stupid, because there are no original. I can give you 50 other proposals that you've all heard about. My God, the Biden Commission. I had a lot of friends on that. They cited me in some footnotes. I had friends on it. What a horrific disaster that was. It's just so hard to change.
Yeah.
2 things I can't let you leave without asking. One is, I don't know if I told you, the organization that we run is pushing for a constitutional amendment to get money out of politics. So I probably know your thoughts on it, but I'd like to hear your thoughts on that. And then I'd like to hear your thoughts on this administration operating essentially, in my opinion, in violation of the Constitution in flagrant manners. But, sort of where we're headed as a country and as a democracy.
Okay, I'll answer both questions. I just want to say the fingers first. If I have skill at this, and I'm not saying I do, but if I have skill at this medium, I have been told I'm pretty good on the radio. I've done a lot of TV. I'm not as good on TV. But everything you're hearing is a product of fanatical listening to sports talk radio as a kid. And so this is very natural. This is very natural to me. And I love doing it because I just was a nerd listening to sports talk radio in New York, of all places, where I was born. And I think I have some feel for what drives things. Okay, anyway, going back to Bobi. So I want to say 2 things about money in politics. Everything you know about Citizens United is wrong. Everything. And the Democratic Party has been an absolute freaking disaster on this. The result of Citizens United is clearly correct. It was a prior restraint on a political movie criticizing Hillary Clinton, saying you can't distribute this to the public. Like, talk about free speech. I mean, it was a prior restraint on political speech. It's an easy case. We can't ban it. You just can't ban this movie. That's insane. It's the rationale of Citizens United that is so terrible. That was then taken forward by the D.C. Court of Appeals and then other Supreme Court decisions, including one called McCutcheon, that really got us to where we are today. Does anybody want movies censored? No. I mean, that's insane, right? And that's what, so Citizens, and by the way, Citizens United was argued very modestly, and then Justice Kennedy convinced Justice Roberts to hold it over a term. And they had it re-argued, and the whole case changed, and they did a whole bunch of things. The Supreme Court has been a disaster on campaign finance reform, and the economists in the room will appreciate this. A colleague of mine wrote an entire book saying whether he was for free market capitalism or not was irrelevant. Those who favor free market capitalism, fine, it's good, whatever, we have in America, whatever. We have a free market capitalism when it comes to elections, and that's insanity. That's crazy. It's not part of the Constitution, and it leads to all kinds of terrible things. And that's the analogy I would use. Of course, the legislatures should be able to limit the amount of money in politics as long as they're nonpartisan limits, as long as it applies to everybody equally. Then, of course, they should be able to do that. Whether that's a good idea, so then the response is, but incumbents who protect themselves and blah, blah. My response is, that's above my pay grade. I'm not talking about what's a better country. I'm just saying the court has no business. Political ads are not allowed in England. They're banned. England has free speech. I mean, just not in that context. So I am told now, as a policy matter, my knee-jerk response is yes, get money out of politics. Put a limit on how much people can spend, how much corporations can spend, and all of that stuff. And then people say, so you're saying corporations have no constitutional rights. I'm not saying that. The New York Times has a right not to be searched illegally under the Fourth Amendment. Of course, corporations have some rights. Of course, the New York Times can print editorials on any subject, or the Wall Street Journal or Fox News can do whatever they want on those laws. But that's not this. Spending money is not free speech. Sometimes spending money facilitates speech, and then we have to have a discussion. But so the case that I really hate, that Judge Posner said Justice Roberts was either lying or stupid when he wrote, and Roberts is not stupid. Posner really said that. He said in Slate, he's either lying or stupid, and he's not stupid. A guy in Alabama wants to write a check to California politician, send him a check, basically. And it's over the limit, the cumulative limit that was allowed for one person to give. And the court struck that down, saying only direct quid pro quo corruption is a legitimate thing that can be regulated. I'll give you $10 or $1 million, you pass a law. Posner said, but people give money to politicians, Slate. People give money to politicians to facilitate decisions they make that help those people economically. And obviously that's corruption. And obviously we should be able to regulate that. I mean, it's not close. That's not censoring a movie. That's censoring the spending of money in a certain way by certain people. That should be a legislative question. I defer to you, Bobi, on your expertise of whether it's a good idea or not. It sounds like a good idea to me, but I'm here to be dogmatic. That's not a Supreme Court question.
Right. So, as we're just saying, we have to do the JD writing requirement. And I was in theories of justice. And mine was whether or not stark wealth inequality comports with the political equality that our democracy is widely held to require. So that's how I got here. And we've got, I think Jesse and Mayhem have already spoken with the professor in that course, which is a little bit more philosophical, but that was a great discussion too. It wasn't on the podcast. We were just talking.
Again, I'm not an expert, but my intuition is get money out of politics.
Yeah, so I say all that to say, and I've given them my paper. I think I sent it to Jesse as well. But I wrote the paper and, analyzing the case law as far back as Buckley v. Vallejo and all of the cases that culminated in Citizens United. So I agree with you. And we often try not to mention Citizens United when we're talking to Congress and tailor our message to counteract any First Amendment concerns and stuff like that, because it is a lot more nuanced than I think the public understands. And so we do our best to explain it.
I've never been a huge fan of the Clintons for a lot of reasons. I think they're warmongers, and God knows Bill Clinton's character is terrible. But when Hillary said that Citizens United was going to be reversing Citizens United was going to be a litmus test for her, I mean, my parents knew them. I have a picture of my parents with the Clintons. What she should have said was campaign finance reform is an absolute essential, and the court should mostly get out of the way. And I would have been totally fine with that. Now, I know saying reverse Citizens United is a shorthand way of saying that, but it's a wrong way of saying it. And now, it's your other question. Oh, go ahead.
Well, I was just saying that, the history of corporate rights and the gutting of our campaign finance just goes back so much further, right? I mean, corporations had rights before.
So my friend Adam Winkler at UCLA has written two of the best books on constitutional law ever written. One on the Second Amendment, which is very neutral, objective book about the Second Amendment and gun rights, and a book about money and politics. And the story of how corporations came to be deemed people under the 14th Amendment is one of the most amazing stories that most people don't know. It was basically
please introduce us.
Say again?
You see me freaking.
Introduce us.
You see me freaking out because that is my personal bugaboo. Santa Clara County versus Southern Pacific Railroad is. Yeah. And you mentioned clerks before for the SCOTUS and like the role of the clerk. And that
wasn't even a law clerk. That was the guy who did the synopsis. That wasn't even a traditional law clerk.
Like you said, I was freaking out.
I'll come back on your show if you have me, and we'll tell that story on the show another time if you have. I do believe corporations have constitutional rights. Don't get me wrong, but that story is everything you know about the Supreme Court comes from that story. I mean, it's insane. Let me talk about Donald Trump for a minute because you asked, and now we end the happy part of the show. You're going to wish you would have asked me about the NBA. By the way, Steph Curry is the greatest shooter of all time, and that's not a close question. And he's probably one of the 10. Well, he's one of the 5 most important players to ever play because he changed the game.
Yeah.
I could give you about 8 NBA players I would choose ahead of him starting a team, but only about 8, maybe 8 or 9, maybe 10. But anyway, sorry. Okay. I wish we had that conversation. I ain't going forever on that.
We will in the future.
My dream is having a law basketball podcast. That's my dream. But anyway, I have absolutely nothing optimistic to say about what's happening in our country. I am asked I've turned down offers to be interviewed saying, I'm going to tell my truth and you won't print it, so it's a waste of time. I was interested that just 2 weeks ago, the LA Times published a quote of mine that even if the court were to rule against Trump on immigration, he wouldn't obey. And I was interested the LA Times actually published that quote. I'm paraphrasing it, that's what I said. I've known about Donald Trump being from New York since the very beginning. The Central Park Five and his behavior towards women are all you need to know. But that's not why I'm so pessimistic. We've had awful presidents before. I mean, really, Nixon and Kissinger bombed Cambodia for no reason and killed generations of people. I mean, starvation. I mean, we've had terrible presidents. If Trumpism is a cult, then America will get through this when he goes away. If Trumpism is a movement, then I think it is. Everything Project 2025 and Heritage wants to do is being done at a pace quicker than anybody thought. And Kim Sheppel at Princeton, who is the leading authority, maybe in the world, on authoritarian movements, has predicted every single thing the second Trump administration has done. She's predicted it with precision. It's just happening faster than even she thought. And now what tyranny looks like in America, what fascism might look like in America, is not what it looked like in 1938 Germany. It's just not going to look like that. If for no other reason than the reason that Brian Leiter, a world-known philosopher at the University of Chicago, but also one of the few world-known philosophers who stands on the ground too, doesn't just talk up here, he actually is both. I view myself not as world famous, but I'd like to think I can do theoretical and be on the ground. He can do both those things too. And he said Trump was going to be reelected a few months before the election. He said it's going to be terrible. And we may, in fact, head towards a semi-fascist state. But what might save us is our geography and our diversity. What does fascism look like in a suburb of Tulsa, Oklahoma? What does fascism look like in Anchorage? What does it look like in rural Georgia? Those are hard questions I don't know the answer to. But I do think that America is going to take a long time to recover any promise of a movement towards egalitarianism as opposed to away from it in the near future. Go ahead, Jesse.
Sorry, this is my shtick, right? I've dedicated this year to reading as many expert and historian opinions and books. Like I have Ruth Ben-Ghiat, Timothy Snyder, Jason Stanley, like Daniel Ziblatt and Steve Levitsky from Harvard, How Democracies Die. So I've just been going through a ton of books about this, and I could not agree more with what you were saying, that we do a disservice when we continue to only use the comparison of Nazi Germany and fascist Italy, because what we're dealing with right now is very unique. I would call it American fascism, right? It's its own brand of fascism. And the reason why I would be careful in comparison, while comparisons can be useful, comparisons sometimes seem to set a bar, right? And that if it doesn't reach that bar or that image, then it's not fascism. But that's not true. That's literally not true, right? And How Democracies Die, I think, is one of the best books I've read recently, because they talk about the characteristics of authoritarianism and how they generally come around through legal means. They use the legal process to actually establish authoritarian rule. And I think what we're seeing right now is American fascism. And I think the answer to what you were saying is spot on, obviously, is what does fascism look like in a multicultural society, right? And I think the answer...
I'm sorry, but geography is big. Germany, Austria, Hungary, these are countries the size of Texas.
Right.
Go ahead, sorry.
No, absolutely. And I think the answer to fight against that fascism is to unite the working class people around a counter narrative to what MAGA is. Because MAGA, by all means, is a cultural movement, right? It is a cultural movement that I truly believe in. Richard Slotkin, who wrote A Great Disorder from Wesleyan here in Connecticut, where I'm from, had written at the end of his book, he absolutely believes that MAGA will outlast Trump. MAGA is here to stay at least for a decade.
So I used to debate with a very, very, I'm moderate far left. He was way left of me even. What percentage of America would go back to segregation? That was our hypothetical question. And I would say 10 to 15%. He would say 35%. He was right. I was wrong.
Yeah.
And I've apologized to him many times now. Now, he also lived in Brussels for many years, and there's 1/3 theory, right? Every country has 1/3 of people that are terrible. And maybe that's right. But our American terrible is completely wrapped around race.
Our original sin.
100%.
It was the biggest issue in 1787. It was the biggest issue in 1865. It was the biggest issue in 1964. And it was the biggest issue in Trump's election, pretty much, except for maybe abortion.
And that's so much of the energy around what's happening right now, right, is they've tapped into this unwillingness to reckon with that, right?
Yeah.
This willingness to look at history square on and see what we've done. Like for me, the big like radicalizing moment, if you want to say, was when Watchmen came out 5 or 6 years ago, and I learned about the Tulsa Massacre that I'd never known about before. I grew up in Oklahoma. I lived about 90 miles from Tulsa. My family has roots going back to that
You
part
weren't
of
taught that in
Oklahoma.
high school?
No, not at all.
Wow.
And the thing that gets, I mean, I was in Oklahoma. The Oklahoma, just, you know, it's a conservative system. They're not going to teach this, right? And like the Oklahoma I lived in, because I lived in from 1976 to 1982, we still had not formally segregated, but informally segregated society. Like when I lived in Prague, we played against Bobi, which was an African-American town. Like when they would show up suddenly, like the band, the entire football team, everybody in the opposing stands was black. And it was like kind of this weird thing for us.
America's still like that.
Yeah,
Today?
yeah. But the thing that gets me, I did have some African-American kids in my classes. And the thing that I think about is like, I was clueless. Every other white kid in that class had no idea. And I will guarantee you every one of those African-American kids did, because they would have family traditions telling you this is what has happened. This is the history. And so that's the moment where I kind of like really, I mean, that and the other thing is like, and all of the continuous cell phone footage that we were getting of police shootings, right?
Yeah.
That's where it was like, okay, I cannot refuse to face reality any longer. And there's a lot of people that just refuse to do that, because I think it's just the lie is so deep and it is so comforting and it is so uncomfortable to turn your eyes to the truth that people are willing to go to extreme lengths to avoid looking at the truth.
Yeah.
Yeah.
And then white people not having an honest conversation with our children is setting them up for failure and embarrassment. And I think that breeds resentment. And all of these things have been captured by Donald Trump and the architects of what's happening here. And I mean, and you know, I don't know.
I have a theory though about that, by the way. He has a savant ability to take a very tiny kernel of truth and use it to build a mountain of lies. But the kernel of truth attracts people, right? There's the kernel of the stereotype, the kernel of the truth. And he's just born with this ability, and it's terrifying.
And I think what happened was the architects behind him, so Techno Bros, Peter Thiel, Heritage Foundation, they spotted a circumstance that might benefit them, and they just said, we'll throw our hat in here, we'll use his cult personality, we'll demolish democratic safeguards with democratic backsliding, and when that's done, we'll sort out power between us.
Which is the way revolutions always happen. We've thought for years the revolution was going to come from the left, and it's come from the right. And that's the way revolutions always play out. There's a coalition of revolutionaries, and once they get rid of the existing power structure, they fight it out between themselves.
Yeah. I used to think only the generals could save us in America from this, but really the Supreme Court couldn't have stopped it, but they couldn't have. But their enabling of it has been truly, I mean, the Trump immunity case.
Yeah. So I want to respect your time. You said you had until 1. That's 4 minutes from now. I mean, generally we like have tying up comments from everybody. So if we can quickly go around the panel for reacts and then let you to go, and I will definitely email you.
Thank you.
So can I just say, as we got this podcast together, and as an attorney, we take an oath to the Constitution and take it very seriously. And I think we're intimately aware when things start to break down like this. If you're a common law, if you will. But so when we've been kind of doing all this talking, and we got this podcast together, and when I thought about the Supreme Court and the cases and what I was watching, your name popped in my head, and I'm so glad that you took this. And I'm smiling not because our democracy is ending, obviously, but because I knew that we were going to align on a lot of this stuff, and that you were going to have the honest, unabashed opinion on these things and tell the truth. And so I really appreciate your time. I really appreciate you coming here today and
Thank
your
you.
honesty. And I think I had a little bit of hope, and I knew, and I'm sure these guys have heard me say, lower courts are going to hold the line, and they tried. And I thought for a minute the Supreme Court
I didn't see that
might
coming. I didn't
ask
see
for.
the shadow docket coming. I have to be honest. I didn't see that. Even I didn't. The biggest critic there is did not see this shadow docket coming the way it's coming.
Yeah. I thought for a minute, I said, you know what, maybe Amy has determined she does not want to vote herself into a Handmaid's Tale outfit. But then they were like, every alley-oop, they could give him all the power and all the American people down the river. And so now we're here to sort that out and see what comes next. But yeah, I mean, I say all that to say I can't wait to have you back. And next time, let's have you debate.
Debate who? I'm sorry, I couldn't hear the end of
I said, next time, let's have you debate Professor Kinkoff.
that. He would agree with 95% of what I just said.
Yeah. Yeah. Oh, one thing I will tell you, the students that we had Con Law 1 with him, we got him to give us like a refresher, if you will, at a brewery. And essentially we were like, this is we know what this is, right? And he was like, well, keep voting, and everybody was like, I need a beer. So I appreciate it. Thank you.
Thank you. And he's great, by the way. So.
Oh, and like I said in my message, you and Professor Kinkoff and Georgia State University and Hull, I think, excellent institution. I wouldn't be the same attorney without you guys. And Georgia State does one thing that other law schools don't do, and they teach you how to practice law before you leave, and not just how to be a lawyer. So
Thank you.
Yeah. First and foremost, Professor Segall, thank you so much for joining our humble podcast. We love these conversations. We consistently say with all the stuff that we deal with throughout the week, this is our favorite part of the week. It's not uncommon for us to agree to go till noon and be here at 1. So thank you. I guess my parting thought will be along the vein that it generally is, and that is they have made a bad bet against the American people, because the American people are undefeated against tyranny, and that's for a reason. And I suspect, whatever happens between now and the reclamation of true democracy in this country, it may be unpleasant, but I think I can tell you what the outcome will be. And so as a student of resistance and resilience across the globe, that is my message of hope for anybody out there listening. And thank you for joining us, Professor Segall, once again.
Thank you for that message.
Yeah, absolutely. I got to say, Professor, it was a complete honor and pleasure having you on. And like Mayhem said, this is the best time of the week. I look forward to Sundays, look forward to the podcast, and to have your expertise and knowledge, just, it's a cherry on top. I'll be honest, until Bobi had sent this earlier in the week, I was unaware of your work, unaware of yourself, and already a huge fan. I look forward to reading this particular article, The 8 Justices Are Enough one. So thank you for joining us, and I look forward to having you on again if you would like so.
Thank you, Jesse. My oldest daughter's name is Jessie, so we haven't finished.
Oh, nice.
Thanks. Yeah. Thank you, Professor Segall. I mean, it's like I've said, there's like a million lines of questioning and conversation that I wanted to explore that we just don't have the time to investigate. And so, yes, absolutely. We're going to want to have you come back here as your schedule will permit. And yes, I will contact you so that we can try to facilitate some.
Thank you. Well, let me just say thank you to everybody. And Bobi's great seeing you again. And I've done hundreds of podcasts. I'm not my own, other people's podcasts. And you guys did a great job. And I think you have a good thing going here. So keep it going. And I do think there's a message of hope. There's a message of cynicism I can glean. I think the combination of that's really good and helpful. And I just hope this is not this particular episode, but I hope this podcast gets off the ground in a world that's very hard to do, because I think you guys are great. And good luck to you.
So,
Thanks.
Professor, one thing I often tell them is, the hope, the United States Constitution is the oldest written founding charter, and continuous use. And I just don't think it ends here. So we're going to do our best.
I hope so. I'm 67, and I sometimes feel guilty that I'm not doing more, but I'm like a lot of people my age. I feel like it's you guys who have to carry it forward.
I sit where I sit, and have my camera set where it is, because I want people to understand I'm just a guy in the bedroom. I'm a citizen in a democracy under threat, and they can do stuff too. I think what we are doing is extremely important in an era of media capture by these deep-pocketed interests. And the fact that we have the ability to do this is super important. So again, thank you so much for gracing
I agree.
our
Thanks,
podcast.
everyone. Really appreciate it.
Yep.
Take care, everybody.
Thank you for listening to the Disorderly Conduct Podcast, a production of the Public Integrity Network. We believe that the first step to taking back our democracy is getting money out of politics. Come find us at moneyoutofpolitics.org and we'll put you to work. In the meantime, get involved in your community. Volunteer at a soup kitchen. Start a rideshare service. Go to school board meetings. Anything you can to make sure this government remembers that their powers derive from the consent of the governed.